When it comes to OHS law in Ontario, some areas are really heating up. In the spotlight right now are the Bill 177 amendments to the OHS Act, sexual harassment, and safety obligations for contract workers. We spoke with Jeremy Warning, partner at Mathews Dinsdale Clark, to learn more.
I would think workplace harassment and contracting are likely amongst the forefront of the issues that we're going to see. It's a common misconception about hiring a company to do a job that may well insulate the contracting organization from health and safety responsibility or health and safety liability. And we normally have to respond and identify that simply because you're engaging an organization to do work doesn't mean you necessarily have no health and safety obligations in respect of that work, and provide advice about how to manage those risks and how do you meet your obligations when you are contracting with other service providers. We are seeing now increased enforcement by the Ministry of Labour when it comes to workplace harassment investigations. And that increased enforcement has now, I think, turned an employer focus to what are their obligations. There have been some significant amendments to the Ontario Occupational Safety Act by Bill 177, which became law back in December of 2017. The significant imports for regulated parties are not only an increase in the financial penalties that are available, where we've seen the government triple the maximum corporate fine available and quadruple the maximum individual fine available. But we've also now seen them modify the limitation period in Ontario to import a discoverability principle. And we think that that's likely going to have a significant effect because it may mean that the Ministry of Labour now is able to take action against parties that may otherwise have been beyond the reach of the legislation. Particularly professionals like engineers or architects who provide advice. If that advice is erroneous, if it results in a workplace hazard, it may be a case that, notwithstanding the advice was given years ago, that a prosecution still could be commenced against the engineer or the architect, given this change in the limitation period. We also think it's likely to affect manufacturers of workplace equipment, or suppliers of equipment that may otherwise have previously been beyond the reach of the Act.
To prevent incidents, fatalities, and prosecution, it's important to do a full risk assessment when identifying hazards in the workplace, even going above and beyond regulatory requirements. For Canadian Occupational Safety, I'm Amanda Siliker.